Alrighty.
So, welcome to the Consultation. My name is Josh Floyd, and this is Christina Jimenez. We're both family law attorneys here in the state of Texas, and today we're going to discuss with you one of the lesser fun portions of civil cases, including family cases, and that is discovery.
Hate it.
Terrible.
Hashtag hate it.
Terrible.
So I guess let's talk about what discovery is. So what is it?
So, it's a means to discover information.
Okay, excellent. So there are typically, I guess, 4 tools that we will use in family law cases when we are dealing with discovery. So there's interrogatories, there's requests for productions, there's Rule 194s, requests for disclosures, and then also depositions, and then also, I guess, expert disclosures too, right? But I guess those aren't necessarily requests; they're just something that you have to produce or send over.
Right. And then admissions.
Admissions, I forgot about admissions.
And so her counting isn't the best, but
3, 6, 4. What?
You don't even, yeah. Okay, we'll go with it.
So, I guess, so essentially, like Floyd said, these are documents that we get to send over to the other side, and we get to say, hey, we need you to tell us, this information so that we can adequately prepare for our case. Okay. So one of the most common tools that we use are interrogatories. Okay. So what are interrogatories?
So interrogatories are where you get to ask 25 questions of your choice. Well, depending on the discovery level that you're under. Most of the time we're operating under 2. Mm-hmm. We're not going to go into all that. But so generally 25 questions. You get to ask them any question that you want. And they have to answer under oath, sign an affidavit stating that their answers are true and correct.
And so, typically it's questions like, if you want to be the primary conservator, tell me why you believe that to be in the best interest. If you own property, like tell me all of the property that the community owns, or even as your separate property. Tell me what it is, tell me how much it's worth, and tell me, if it's community or separate. If you want to divide the property, tell me how you want it to be divided.
If you've been in an intimate relationship, who were they? When was it?
Mm-hmm.
If you used drugs.
When did you do it? What did you do? If there are allegations of family violence, either allegations that you've made against the other party or that they're making against you, they tell us all about that information.
Giving away money.
Yeah. If there's reimbursement claims or fraud claims, tell me about these issues. And so honestly, there's a whole bunch of different questions that you can ask, and obviously the attorney that's handling your case has to go in and try to narrow down those questions so that you're able to obtain the information or the answers to the questions that are going to be most relevant to your particular case. Okay.
Sure.
And so sometimes narrowing it down to the 25 questions is difficult.
True.
We have the ability to request additional questions, but like Floyd said, we're not going to get into all of that. But I will say that typically those interrogatories are important because it provides, once we get those responses back from the other side, it gives us some insight of where are they going with this, right? Like, what are they going to argue? Are they going to allege a reimbursement claim? Are they going to allege separate property? Are they going to fight for primary custody? If they want supervisor restricted access for the child, what are they claiming that you did? And so what it does is it gives us the ability to either prepare for a deposition or prepare for mediation or prepare for final trial, right? So I will say that a lot of times when we're answering those interrogatories, it doesn't have to be an exhaustive list, right? Like, we don't have to say everything with specificity, but just enough for them to understand, okay, these are going to be issues that will be addressed in the court.
Correct.
Right? Okay.
True.
So Rule 194 is request for disclosures. Those are pretty simple. It's kind of like, tell me the parties, tell me
legal theories.
Tell me, if there are, I guess, experts, things of that nature. And so those are kind of general information, not anything too crazy. The next issue is the production, and I think that's kind of the meat of
I don't know why
most
that's
cases.
not limited.
Yeah, if they limit interrogatories, they should most certainly limit production.
People get crazy with request for production. Yeah, so request for production, basically you can just ask for anything that you want within reason, right? It's got to be relevant and all that stuff, but anything you want. Give me all your bank statements, all your credit card statements, your phone records, your social media accounts, your inventory appraisals, your DNA sample. Not really, but literally anything that you want, you can ask for. Text messages.
Social media accounts.
Yeah, when I said social media accounts, she wanted to
did you
repeat
say that?
Yeah.
I didn't know that. I didn't hear
She
you.
wants to emphasize social media accounts. So you could probably do social media accounts, I think, also.
What else? Credit card statements, did you say that?
Yeah, I did say that, yeah.
Okay.
Phone records also said that.
Okay. Any documents that you're going to use in trial.
Income information.
Yeah, and tax returns, financial statements, so balance sheets, profit and loss statements.
Contracts with experts.
Yep, if you have a business, anything that's relevant to that particular business, anything that's relevant to any purchase of property, contracts, outstanding mortgages. And like Floyd said, there's no limit on the number of questions that they can ask. We once had, I think it was like 127 questions or something ridiculous
BS.
that another attorney sent over to us. And unfortunately, you have to answer them, right? And so most of the time when an attorney is asking that many questions, most of it is not going to be we won't have anything to respond to, right? They're really getting nitpicky over silly things, and would likely not be relevant to our client's particular situation, which is why we always do our best to really limit the scope of those production requests. I think that a lot of attorneys maybe just have like a template that they use in all of their cases. And, especially in the context of a divorce case, I don't think that is best practice, because what's left over at the end of your divorce case, like whatever funds are left over at the end of the divorce case, it's subject to division, right? And if I have an attorney on the other side sending over 125 requests for productions, and it's taking my office 20 hours to respond to that production, all we're doing is dwindling the community estate, which means there's less money to go around at the end. And so I, as an attorney, would never recommend that. As a client, you get to kind of help us and guide us and tell us what to do. I would encourage you to tell your attorneys, like, we don't need all that stuff, don't care about it. I know that there's no cryptocurrency, right? I know that, there's not a business. I know.
The question I hate the lottery ticket question. Not one time have I had anything responsive or received anything responsive to the question about lottery tickets.
I mean, I get it. I understand.
I hate it. Like, really? Lottery ticket?
So it is important that you do your best to try to narrow the scope of those things, because.
And if you think they won the lottery, ask.
But I will say that asking the questions is not the expensive part of the process, right? Like, that's just a draft of a document. The part that is most frustrating for us and most frustrating for our clients is the responses to them, right?
Yeah, I think that when people send over, like you said, 120 requests, right? So sometimes it's their client being a jerk, right? And wanting to run up fees, which they do, right? Because it's expensive to go through. But they don't realize that when you get all that stuff back, I've got to review all of it, right? I mean, thousands and thousands of pages of documents, and now you're going to be billing your client to go through all that stuff. So it's a waste of time and waste of money.
Right. So
but responding is expensive.
The other thing that I will tell you is to limit the scope of the time frame, right? And so when I first started, this was kind of a rookie mistake that I would do.
Well, they have a family code when you first started?
This is a rookie mistake that I would do, is I would ask for, like 5 years of bank statements, or 7 years of bank statements, or 7 years of pay records. And as
Such a rookie.
And as I have matured, I learned like, hey, I don't really need all of that, right? Like it's not, there are some cases where it might be relevant, right? Like if there's a reimbursement claim, or if perhaps there was, fraud, or perhaps we thought that there was an affair going on. But in most instances, it's not going to be relevant, right? So I'm going to limit my bank statements to maybe a year, maybe 2 years, right? And I'm going to, limit maybe my W-2s to the previous 2 years. And so when you're drafting these things, you really have to kind of stop and think about what do I actually need to prep this case? Because if I ask for 7 years of bank records and they give me 7 years of bank records, number one, it's wasting the money of the community estate. And number two, am I going to actually sit down and go through all of that?
And going through that stuff is so boring.
Right. And number three.
Unless you're on a mission, then it's fun. If you know something's there, it is fun.
And number three is if the other side objects to it, or if you have to file a motion to compel because they only gave you 2 years of bank statements and not 7, and you have to go in front of a judge and they say, why do you need 7 years of bank statements? You better damn sure have a good reason as to why you're requesting those 7 years, because otherwise that's going to frustrate the judge, right? So make sure that you're asking for the things that you need and really only that. If there's things that you don't know, I think it's fair game, right? If you don't know if there's cryptocurrency, then yes, you absolutely should ask. But if
You
it's
generally know if they won the lottery.
yeah, so maybe you don't know. So maybe just ask. I'm gonna
Don't
ask
ask
the
the
lottery
damn lottery
question
question.
from this point forward, and I'll discover
I
your
hate that
ignorance.
question.
And every time I see it, I'm gonna laugh now. I'm thinking Floyd, grumpy Floyd. And so yeah. But with the production, I've had so many clients who are like, I'm not going to give them this information. Like they don't need to know that. They don't need access to my, bank statements, or they have that access. They can get it themselves. I don't need to give it to them. And
You
so
still have to produce it.
you still have to produce it.
So one time, another thing you got to be careful of, I learned this lesson the hard way, is this attorney was not being very friendly, and so I sent over a bunch of requests for production. And he literally just hand marked out his name and wrote my name and sent it right back to me. I'm like, oh, son of a gun.
See? Yeah, rookie
Damn it.
mistake.
Yeah.
So
She just asked for 7 years bank statement or something.
And so production is tedious, and it's going to take a lot of your time. It's going to take a lot of our time, but unfortunately, it's necessary sometimes, and the judges are going to enforce that.
That is expensive because you've got to go get all those documents, right? And which is time consuming for you. But then you get it to us. We've got to organize it. We have to base label it, which is basically put page numbers on it. Mm-hmm. Then we have to go through the page numbers and on the request for production say, see this page through this page for each one of the damn questions. Mm-hmm. Yeah. Well, we're supposed to. Some people don't.
Right. We do.
We do.
And so you also have depositions. And so
depositions, yeah.
So depositions are basically an opportunity for us to obtain testimony prior to a trial, okay? They're a very useful tool, but they are expensive, right? And so typically the way that we like to do it is we like to do the paper discovery first, right? We want to do our 194s, our production. Oh, we're forgetting about admissions. Before we go to depositions, let's talk about requests for admissions.
Okay, good idea.
What are they?
Again, they're questions. You can ask any question that you want. I don't think they're limited either, are they? Mm-mm. Yeah. But they have two answer choices, admit or deny. And those are under oath as well. And so you would just ask a question. Is it true that you are sleeping with Joe Bob's aunt?
Admit or deny that you are sleeping with Joe Bob's aunt.
Yes. And they would circle admit or deny.
And so I would say that we are very careful about how specific we are when we're asking these questions, right? And so we might not say sleeping with, that we would say that you have had sexual intercourse with Joe Bob's aunt, right? Admit or deny that, because they're hyper technical, and so he could say, well, no, I've never slept with her, I've only had sexual intercourse with her, so I'll go ahead and deny that bad boy, right?
Yeah, you got to be careful as wording.
Yeah, and so we want to make sure that we're very specific, that we're asking like I guess, tiny questions and not compound questions, because they could admit something and deny something. And if it's not all true, then they're just going to deny it.
I tell my clients it's like when we were learning true or false questions in elementary school. If any part of it's false, the entire thing is false.
Right, right. But I will say that I think that those requests for admissions are very powerful tools, because, we've had it happen before where the father had sent some very inappropriate text messages to the mother. And so it was admit or deny that on February 15th, 2023, you called mom a B word, right? And he had to go through and he had to admit, yes. And we laid out every single one of these messages. And so when we got to trial, that was an effective tool that we could say, okay, here's the request for admissions. You admitted all of these things. And I didn't have to go through and lay the foundation for each one of those text messages, because he had already admitted it in those requests.
They're also really useful when you're dealing with element-based issues, right? Like for spousal support or whatever, whether or not you have the sufficient means to provide for your minimum necessities, all that stuff, right? Because you can break each one of the elements down and either prove it up or disprove it based on the admissions alone. Yes. And if they don't answer them, they're all admitted. So that's the way you want to draft the questions.
And I'll say that a lot of times, and it depends on, how savvy my client is, but a lot of times I will tell my clients, draft these questions for me, right? Like, go ahead and write them out. I think it's therapeutic for you guys. I think that it is something that kind of helps you think about the case and the strategy of the case. And I think it saves you guys some money, right? Now, obviously, they send it over to me. And when they send it over to me, a lot of times I'm striking about 50% of it. I was like, yeah, you can't ask that.
Like your questions suck.
Or let's maybe tweak this a little bit. But it does help, right? It helps the process, it helps save the money, and it helps them from a mental health perspective as well. And so that's a very, very powerful tool that sometimes I don't think attorneys use enough. I don't think we use it enough now that we're talking about it. Yeah, yeah. So once we get all of the paperwork back, right? So the production, the interrogatories, the Rule 194s, and the admissions, we will oftentimes, or every time, take all that information, we review it with our clients, right? And I guess let's talk, before we get to depositions, let's talk about when we get it, if it's not sufficient, like if they're not answering the questions, what happens?
So then we'll send a letter over to the other attorney and say, we appreciate your attempt, but you failed, and you are missing A, B, C, D, E, F, G.
And so, pursuant to the rules of civil procedure, you have to send that letter, right? You have to send them some sort of document, or putting them on notice of, you failed to comply with this, and we need you to do these things. Otherwise, we're going to have to move forward with a motion to compel. What's that?
That's a motion to compel, is where you tell the court this guy didn't do what they were supposed to do, and you're asking the court to order them to produce documents or whatever it is that they're lacking, and requesting attorney's fees.
So I will say I absolutely hate motions to compel. Like, I hate them. Yeah. Because, and I will also say that is a process that is so frustrating for our clients, because it's like, there's already a rule that says that they have to give us this stuff, right? They have 30 days to respond. They didn't comply with the rule, and so why do we have to go to court for the judge to tell them to comply, right? I get it. I 100% understand that. But it's the same thing with like an order, a divorce order, a custody order. When people are not complying, then you have to file enforcements, right? There's only so much that the legal system can do when somebody's not doing what they have to. And so I think motions to compel are, it's frustrating. It's a waste of money, but sometimes we have to do it. Now, I will say, we have received discovery deficiency letters in some of our cases. We have received motions to compel in some of our clients, and when we get those, we do our best to get all these documents, because we don't want to go to that hearing, right? We don't want the judge to look at us and say, why didn't you turn this over? Why didn't your client turn it over? Because it just kind of paints you in a bad light. And so, are there going to be things that we miss? Yes, we're not perfect, right? But once it's brought to our attention, we're going to make sure that we're addressing those issues, we're answering the questions, we're producing the documents, or we're responding to the letter and saying, hey, I know you're asking for, these bank statements from 5 years ago. Unfortunately, that account was closed and my client does not have access to those accounts anymore. And so we cannot, they're not in our possession. We cannot obtain possession. And so that way the attorney at least knows why they're not getting them. They can still try to compel it, but we can at least say, Judge, we tried to tell them we didn't have this. We don't know what else to do.
Yeah, and not complying with discovery can have terrible sanctions, in addition to the attorney's fees. But if you have to go back, then it's the death penalty sanctions. They can strike your pleadings and make affirmative findings, and
they can bar evidence.
evidence.
And so today I was over in Dallas and I was waiting on a hearing, and I sat in and I was watching two separate firms going at it, and apparently the husband had some businesses. There were some fraud allegations that he was hiding money from the wife. These people had filed, like the mother's attorneys had filed 2 or 3 motions to compel. They had tried to set depositions on 2 separate occasions, and there had been lots and lots of litigation as it pertained to discovery. This firm, the mother's firm or wife's firm, was asking for $750,000 solely as it pertained to the discovery issue. And so, right, but
I hope they had very detailed attorney's invoices, because there's that new law stuff.
Yes. And so it was, and honestly, it was kind of funny because I was looking at the judge waiting for her expression, like I expected her to balk at that, and she didn't. This case had been going on for about 2 years from what I could gather. And the
I want
father,
$750,000.
Right. The father was, or the husband was just doing everything that he could do to not comply, right? Not showing up to the depositions, not turning over evidence. And I was listening to his attorney, and poor thing, she was in panic mode, rightfully so, because now that they were close to trial, it's in a couple of months, they needed to turn things over to prepare their case in chief. And they needed to do discovery as well. And judge was like, too bad. Like, you didn't do it. He's had all this time to comply. He didn't do it. She was like, you can supplement, but there's not going to be any new or additional evidence because he should have done it in, way back when, which is terrible. Because imagine showing up to a final trial and not being able to present your case because you didn't comply with discovery.
So did they get the attorney's fees?
No, it's reserved for final trial. It will be determined.
I also hate that.
That's frustrating. Yeah. So on a motion to compel, when you go in, you can say, hey, Judge, I want my attorney's fees because we had to file this because they didn't comply. In a divorce, Floyd, you're so grumpy today.
Well, my client didn't have to wait till final trial to spend it.
Right. And so he hates this topic. We should have chosen a different topic.
I do not like discovery.
And so it is, and it's frustrating for clients because, and I don't understand why judges do it really, because it's like, hold on, now we're showing up to this court hearing, we're out, $1,500 to maybe $3,000 depending on.
Not $750,000.
No,
that's never happened.
$750,000. But it's a few $1,000s just to get to this hearing, and then for the judge to say, yeah, I'm not going to order that right now, I'm going to order it at final trial. There's no consequence for the other side, like not doing what they're supposed to do, right? And so we do our best to try to paper it up to say, okay, we're going to give you a week or 2 weeks to get this done. Oh, 2 weeks have passed. You haven't given it to us. We're going to send you another email. We're going to send you another letter to basically say, look, Judge, we made multiple attempts before wasting your time on this motion to compel. And they still didn't comply. So will you please give us the attorney's fees?
They say no. We'll reserve that for final.
Not always. I would say it's probably about a 50-50 chance that you get it at the hearing. And it also depends on the reasons for the non-compliance, right? So a lot of times what we see is that attorneys fall on their swords and they say, well, I missed the deadline, or it felt my paralegal, I thought she sent it and she didn't. And in those particular circumstances, judges are not going to really ding the client for that, which, I guess is good.
Yeah,
It's
shit
good.
happens.
Yeah, it does. But the frustrating thing is whenever you have a party that is just like not doing it, don't want to, not going to ever, then it becomes okay, now you need to get some money from that. So typically, first motion to compel, the judge will say you have so many days to get this over. You need to pay attorney's fees by a date certain. If you do, then great. Everything's cool. We proceed. If they don't comply with that order, then
You file a second motion to compel.
yes. And at that point, you can request, sanctions, right? So you can say, Judge, want you to strike their pleadings, want you to deny or bar their evidence. You can.
If it's like financial stuff you're wanting for child support, you can ask for an affirmative finding that they're maxed out.
Right.
Stuff like that.
So.
Or separate property issues.
Right. And so, obviously, you don't ever want to be in that position where you're getting a second motion to compel, because it's when it gets pretty ugly. So,
Yes.
let's say that they do comply, they give us all the documents that we need. Then at that particular point, we might want to set it for a deposition, which is another discovery tool.
It is.
What is it?
So it's kind of like court in a way, right? I mean, you're sitting there, you have both attorneys, generally both clients, you have a court reporter, and you just ask the other party questions. Any question you want to ask.
Yep. So they'll get sworn in, so it's sworn testimony. It typically will be permitted to be used in court. There's some kind of funky rules that we won't get into. But it's a great tool because, typically what you'll do is you'll have your documents there, you'll have your admissions, or you'll have your interrogatories, and then you'll be able to go in and say, okay, let me talk about this document, right? You produced this. What is this? What did you mean by this? Or you're alleging that this property is separate estate. Why do you believe it's separate property, right? You think that my client is a bad mother. Why do you believe that? Talk to me about this, right? And it's a great tool because the interrogatories, they're going to fill them out, but their attorney's going to go through and kind of clean it up for them, right? When you're acquiring live testimony, the attorney really can't save them, and so you get to kind of lock them down on this is what their testimony is now. They might try to change it at the final trial, but you already have it locked down so that you can use it and bring it to the attention of the court.
Yeah, and like I said, it's under oath. There's a record, so if they try to change it at final, you can always bring that up and say, that's not what you said 2 months ago.
Right. So depositions are expensive, right? And so you don't see them a whole lot in the context of family cases, unless we're dealing with the big estates, right? But I love doing the depositions. I love doing the discovery because I like to be prepared for final trial. Right?
Yes.
And so if you don't have this information, it is very, very difficult. I mean, you're basically flying by the seat of your pants, right? When you walk into court, you don't know what exhibits they're going to use. You don't know what witnesses they're going to call. You don't know, what are they fighting for? Like, what should I have in my possession to defend against these allegations?
And that's really the purpose of discovery, right? Is to avoid trial by surprise, right? So everybody shows their hand. Can you settle the case, right? This is what I'm going to present. This is what you're going to present. And sometimes you can't. You go to trial, but at least you know what's coming up. Everybody knows what's going on. And you're ready for it.
Well, and I'll say that I cannot say the number of times that I've been like, okay, we're ready to go to trial. We're going to win primary. We're going to win, 60% of the estate, and we have this great case. And then I get the discovery responses back, and I'm like,
shit.
I'm like, oh.
They're going to win primary. They're going to win 6.
So, Mr. Client, we need to discuss this because you failed to disclose some information to me. And so those are interesting talks. But like you said, it gives us perspective, and it really does put us in a position of, okay, now that we know what our evidence is and we know what their evidence is, this is what the court is likely going to do. Right? And so here's what we really need to go for it to reach a settlement. Right? When we settle cases. We've been, fortunate enough to be doing this for a very long time, and we practice mostly in front of the same judges like all the time. And so we have an idea just based on our experience of what their opinion is going to be on these issues, right? And so when we have all of the information, we try to settle as close to what we believe the court is going to order, if we have to go to a contested final trial. And I think that as attorneys, that really is best practice, because you're getting the same result without wasting your client's time, your client's money, without putting them through the stress of litigation. And so that's best practice. And I always like to practice against really good attorneys on the other side, because typically if you have two good attorneys on the other side, we all have the same mindset of this is what we know is going to have, and let's just
Did
get
you
it
just
done.
lump yourself in with a good attorney?
Yeah, great
Okay.
attorneys, exceptional attorneys.
We all.
We are all. We are this way. And then so I want to be able to reach those agreements for my clients. But sometimes you get not so great attorneys, or maybe unreasonable clients on the other side, and you have to move forward.
Makes it really difficult to settle because or out of county attorneys, right, that don't know the judge, right? And I'll try to explain that this is what the judge is going to do. And they don't believe you or whatever, and you can't settle. So then you just have to try the case because they don't understand the court. They don't understand what's going to happen. And then you try the case. And it costs everybody a bunch of money, unnecessarily.
But you have your discovery, so you're prepared, and hopefully you'll have favorable outcomes. And so I know that discovery is a painful process.
Nightmare.
Like, I know you don't like
I hate it.
but I think that it is a necessary tool.
It is necessary.
And that we have to learn to at least like it.
No. We have to learn to accept it.
We're going to accept it. And so, or you could have a psycho on your team.
We have a psycho.
That loves discovery.
More than one, but
yes.
This one particular.
I loves doing discovery. So that's a blessing for us, because we're like, great, here you go. So if you're a client, if you're an attorney, I would encourage you, despite the fact that, yes, it is a pain in the neck, make sure that you're doing discovery so that you can be prepared and you can negotiate from, an area of knowledge of what the other side is going to be presenting.
It's less of a pain in the neck if you cater the discovery to your case and not do BS discovery.
Right. Anything else on discovery?
No.
I feel like that's it. Yeah. That's it. So, as always, thank you guys for watching the consultation. Do not accept this as legal advice. If you find yourself in a discovery issue, make sure that you're talking to your attorney or to local counsel that practices in your jurisdiction. Follow us on all social media platforms. We have Facebook, Instagram, YouTube, TikTok. If it's out there, we are on it. And hope you guys have a great day.